So we are going to see the topic board meeting in company law. So we are going to see meetings of board as prescribed under section 173 of Companies Act 1956 and 2013. So every company shall hold the first meeting of the board of directors within 30 days of the date of its incorporation, and thereafter hold a minimum number of 4 meetings of its board of directors every year in such a manner that not more than 120 days shall intervene between 2 consecutive meetings of the board. That is, the board need to meet yearly with a gap of 120 days between the first meeting and the second meeting, and every company is supposed to hold a meeting between after incorporation. It need to conduct a board of directors meeting within 30 days of the date of incorporation. So per year they need to conduct minimum of 4 meetings of board of directors to be conducted every year. So the participation of directors in a meeting of board, either it can be in person or it may also be video conferencing or any other audio visual methodology as being prescribed by the central government, may be conducted. Every officer of the company and whose duty is to give notice under this section and who fails to do so shall be liable to a penalty of 25,000 rupees. In case of one-person company and small company or a dormant company, it shall be deemed to have complied with the provisions of this section if at least one board meeting of the directors has been conducted in each half of a calendar year, and the gap that is between 2 meetings is not less than 90 days. And for the board meeting, the quorum is supposed to be fixed and is stated in the sections 174, and the quorum for the meeting of board of directors of a company shall be 1/3 of its total strength or minimum 2 directors, whichever is higher. And the participation of the directors by either it can be by video conferencing or other audio visual means shall also be counted for the purposes of quorum. And the continuing directors may not act notwithstanding any vacancy in the board, but if and so long as their number is reduced below, that is the fixer that is being fixed, if the number is below the quorum means the continuing directors or director may act for the purposes of increasing the number of directors so that fixed for quorum, or of summoning a general meeting of a company and for no other purpose. And where at any time the number of interested director exceeds or is equal to 2 directors of the total strength of the board of directors, the number of directors who are not interested directors and present at the meeting being not less than 2 shall be the quorum during such time. And the last thing is, the meeting shall automatically stand adjourned if there is not sufficient number of members present for that particular day meeting, and the same meeting can be standing adjourned to the same day at the same time and place in the next week, or if that day is not national holiday, till the next succeeding day which is not a national holiday, and the meeting stays adjourned at the same time and place.